Before this hearing even begins, you can already feel the tension brewing. This isn't just another routine eviction case. This is a collision between landlord authority and tenant rights, and it's about to get complicated. On one side, Walnut Meadows Apartments, claiming they simply chose not to renew a lease. On the other, Susanna Hostetler and Ronaldo Austin, tenants who say they paid their rent, asked to renew and are now facing removal despite disabilities in the household. Here's where it gets interesting. This is not filed as a non-payment case. It's a termination of tenancy. That distinction matters. In a market-rate apartment, landlords often have the right to end a month-to-month tenancy without giving a detailed reason. But once disabilities enter the picture, that changes the legal landscape, and if rent was accepted after the notice to quit, that could completely derail the landlord's case. So ask yourself this: is this a straightforward lease expiration, or is there something deeper happening behind the scenes? Are we watching a landlord exercising their legal right or a procedural mistake that could cost them everything? Stay with this one, because before this hearing ends, the judge may end up schooling the landlord on their own eviction strategy, and that twist could shift the power balance entirely. Let's get into it.
Next is Walnut Meadows Apartments versus Susanna Hostetler Ronaldo Austin. Are you Susanna Hostetler?
Yeah, Anna's just my nickname.
Okay. Is Ronaldo there?
Yep.
All right. He's sideways. You're all
Oh,
sideways.
Let's see if I can. Does that work better?
Yes.
Okay.
Mr. Thornton is here, and Judy, the manager, is also present. This is filed as a demand for non-payment of rent.
Your Honor, actually, it's a termination of tenancy.
No, it is. Let me look at my note. There is no lease. It is filed as a termination of tenancy. Notice to quit was filed on October 20th. Mr. Thornton, what are the premises here?
An apartment at the Walnut Meadows facility. The lease expired in 2023. It was not renewed. So the tenants have been on a month-to-month tenancy.
Is this market rate or is this subsidized?
No, it's market rate to my knowledge.
Is that correct, Judy?
Yes.
All right, Ms. Hostetler and Mr. Austin, they can elect to continue with the tenancy month to month. Very often leases are for a year. When the year expires, then they just renew automatically month after month. In this case, they don't wish to have you as a tenant anymore. They served a notice to quit in October, giving until November to vacate. You didn't move, so they filed this action to get me to order you to move out. What's your position?
My position?
Yes.
First of all, my position is I asked her to let me sign a lease.
Okay, pause right here. Notice what Susanna is doing. She's not denying the lease expired. Instead, she's reframing the issue. She's saying, I tried to renew. I paid my rent. I asked for help. I even offered to cover damages. That's not the posture of someone refusing to comply. That's someone building a record. And here's what's legally important: documentation. She mentions messages, receipts, photos, money orders. In housing court, paper trails are everything. Judges don't rule on emotion, they rule on evidence. But there's another layer. When she brings up disabilities, her own, Ronaldo's, and her autistic child's, she's subtly introducing potential fair housing considerations. If a termination appears connected to behavior that could be linked to a disability, that can raise red flags. So now the question becomes, is this simply a non-renewal of a month-to-month lease? Or could this drift into discrimination territory if not handled carefully? And you can already see the judge leaning in. This isn't going to stay simple for long.
My advocate contacted her and said I needed help. She told me I could stay, that she would send me a new one. I have messages, pictures. everything on my phone of pictures of stuff they didn't fix, stuff they charged me for. They charged me for a bathtub that was over $800. And I paid my rent on time. I had money orders from all the receipts that I paid and all that stuff. I offered to sign it. They said I could. I never got it. Never got a mail. They did replace my mailbox key, but I lost it because it got lost in my purse, and I offered to pay for a new one, and they wouldn't give it to me, and they wouldn't come fix my stuff until my sister messaged them. Then they came down. They came down and fixed my fridge, and my advocate is actually here with me who can prove that. And they wouldn't fix my fridge. They wouldn't fix my key. Give me a mailbox key, another mailbox key, even though I offered to pay for it. I offered to pay for damages, and I offered to pay for the rent if it went up. And I have an autistic child. I have a documented disability, and so does Ronaldo.
You have a disability and Ronaldo has a disability?
Yes, I have documents, and so does my daughter. And I have the documents on my phone to prove that. And I signed a paper saying my sister could speak for me, and we dropped it off, and they still wouldn't talk to her. And I signed it and have a video of me dropping it off.
So it's safe to say you don't want to move.
I don't. I have been looking, and I did get in contact with the place. I am just waiting for them to get authorization from their company. But this will take a few more days. It shouldn't take too much longer because I was in contact with them today and gave them. But I would like to stay at least until I can do that, because I've been sick recently and my daughter's been sick, and it's just, I've been working on it though, like a lot.
Everybody's been sick. All right. Well, Lance, what of all that? And Meg?
The Walnut Meadows position, Your Honor, is that Ms. Hostetler and Ms. Austin, in short, are problem tenants that create a lot of noise and a lot of issues for their surrounding tenants, to the point where Walnut Meadows is having tenants threaten to leave. That's in short, the reason for the non-renewal of the lease.
Because my daughter is autistic. But they're saying that it's because my daughter is filed because she's autistic.
All right, so it wasn't filed as a just cause termination, just expiration of the lease.
Correct.
All right.
Judge,
Ms. Hostetler, I got a view of your ceiling, I think.
Sorry.
All right, so they didn't file it as a demand for a just cause, but apparently they've got reason why they want you guys to move out. Now, you raised some issues which could constitute some defense to this. And you're also looking for another place to move to. I see that you're in outer space there.
No, I don't know
Not
how
sure
to move.
what
Okay, I
planet
got it.
that
I got it.
we're on this planet. All right. Now, if you get evicted from here, it may make it very difficult for you to get in anywhere else.
Yeah.
Reason for leaving last apartment evicted.
Yeah.
Perhaps there could be something else worked out if you find another place to move to.
Judge, I did hear the tenant indicate that she's paid her rent in full. So I would have some part four
Yeah,
questions.
that's an issue that passed me by, Meg. Thanks for raising it. They served a notice to quit on October. So are you saying you've paid November and December's rent?
Yeah. I have the receipt. Where is it? Right here on this, right here.
Mr. Thornton, what do you know about that?
This, right here, is the turning point of the entire hearing. The landlord filed a notice to quit back in October. That notice is supposed to signal the tenancy is over. Clean break, no continuation. But then they accepted November's rent and December's rent. That's a huge procedural issue. In many jurisdictions, once you file a termination and then accept rent covering a period after that notice, you may have just reinstated the tenancy. In other words, by taking the money, you could be signaling that you're okay continuing the rental relationship. And listen to the judge. He immediately references case law and warns them. Once you file for termination, you cannot keep collecting rent like nothing happened. That can nullify the notice entirely. So now ask yourself, was this a simple oversight by management or a costly legal misstep that could force them to start the entire eviction process over? This is why eviction law isn't just about wanting someone out. It's about following procedure perfectly. And Walnut Meadows might have just tripped over that line.
I just, last 2 days determined that and heard from Walnut Meadows that she did pay December's rent. Obviously, they will not be out until I've instructed Walnut Meadows not to take any further rent, and they will not be out by the end of December. So our position would be that we're not accepting any rent for January and would like to
Well,
proceed.
as you know, the Park Forest case says once you file a tenancy, you can't accept any rent. And Ms. Bauer's theory would be the remedy would be dismissal and start all over again. It nullifies a termination of tenancy. And Judy, you should learn this. Once you file a notice to quit on a termination of tenancy, you can't accept any money. The acceptance of money, according to the case, is an indication that you're willing to continue the tenancy. So the notice to quit was filed in October, and in the meantime, you've accepted November and December's rent. So I can go a couple ways with this. I can just dump it and make you start all over again, or I can continue it and see where we are, but I don't think you're gonna have the jurisdiction to go forward. Let's continue this.
Good afternoon, Your Honor.
Good afternoon.
I'm on Midland Funding versus Clotis Weary.
Yes, is that you, Mr. Sefton?
Yes, ma'am.
I think he's in another court. I'll put it back in the waiting room.
That's their attorney.
Ms. Hostetler, I'm gonna let you speak to Ms. Bauer.
Okay.
Now, a couple things. Eventually, if they get what they ask for, they can probably compel you to move.
Okay.
So there's some problems with the way they've handled the case so far, but their intent is to get you to move, or other tenants are gonna move out. And so the best solution would be if you could find another place to move to. But right now, you don't have to do anything because I haven't made any sort of ruling, but we're going to
Okay.
revisit this.
Sorry, my nose hurts.
All right, Lance, how is Friday, January 2nd at 1:30?
That's open.
All right, now you have a market rate lease. It's not subsidized, but your claim is that you and your co-tenant and your son have a disability, which could affect their ability to do a termination without just cause. Then the next issue is they've accepted your rent, which may make this case terminal. We may have to.
The judge just laid it all out clearly. Two major legal pressure points. First, disability. If Susanna, Ronaldo, and the child have documented disabilities, that doesn't mean they can't be evicted, but it does mean the landlord must tread carefully. If complaints about noise or behavior are tied to a disability, the landlord may be required to consider reasonable accommodations before terminating the tenancy. Second, rent acceptance. If the landlord accepted rent after filing the termination, that could wipe out the legal effectiveness of the notice to quit. The judge even hints that this case might need to be dismissed and refiled properly. So instead of a quick removal order, we now have uncertainty. The landlord wants them out. The tenant says she's trying to relocate but needs time. And legally, the landlord's own actions may have bought the tenants more runway. Let me ask you, if you were the landlord, would you have refused rent entirely after filing? Or was collecting rent a necessary business decision? This case just shifted from routine to strategic.
Start over again. But let's see how you're doing between now and January 2nd in finding other housing. Miss Bauer is here from Legal Aid if you wish to consult with her. Would you like to do that? Miss Hostetler?
You say that one more time? Sorry.
Would you like to consult with the lawyer from Legal Aid?
Yeah, I have one that I've contacted. You mean this lawyer?
Yes, she's quite famous. She's here from Legal Aid.
Okay,
And
okay.
all right. I'm gonna put you in a breakout room with Ms. Bauer and let you discuss some of these issues. But right
Okay.
now, I'm adjourning this case till Friday, January 2nd at 1:30.
Okay.
All right, let me put Meg in there. All right, you hit the button that says join.
You? Where do I click on?
Let me see.
I don't see it.
Ms. Hostetler, hit the button that says join and you go into the breakout room.
I don't see that anywhere.
It just says leave.
Can you see it, Meg?
I got it, Judge, yeah.
All right, yeah, it's a button that says join somewhere. I'll put you in a breakout room.
Okay, I don't see it. Let's see. Would it be under, where would it be under? I can't see. It doesn't show anything that says join on mine. It says
Does
leave.
it show? Yes,
Just hit leave.
No,
no.
Okay.
Does it show a breakout room?
Not that I'm aware of. I don't think so.
All right, well then get a pencil and write this down.
Okay, one
Madam-
second.
Judge, I see Ms. Hochsteller does have an intake with us, so I have her phone number.
All right,
Okay.
you already got an intake set up with Legal Aid, so just keep that appointment, okay?
Okay.
All right, you're good to go. I'll see you after Christmas on January 2nd.
All right. Thank you so much.
Thank you.
Thank you, Judge.
Thank you, Mr. Thornton.
Yep, thank you.
So here's where we land. Walnut Meadows sought to terminate a month-to-month tenancy after the lease expired. The tenants argued they paid rent, requested renewal, and raised concerns about repairs and documented disabilities in the household. The critical legal twist: the landlord accepted rent after serving the notice to quit, a move that, under established case law, may invalidate the termination and require the process to restart. Instead of issuing an eviction order, the judge adjourned the case, encouraged legal consultation through Legal Aid, and scheduled a future date to revisit the matter. No immediate eviction, no final ruling yet. What this hearing teaches us is simple. Eviction cases are rarely just about move or stay. They're about procedure, timing, documentation, and rights on both sides. One procedural error can shift the entire outcome. Now we want to hear from you. Was the landlord justified in ending the tenancy? Or did procedural mistakes undermine their position? Should disability considerations weigh more heavily here? If you found this case as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.